After all the bad things that happened to Mr. Sakuna, this case is a glimpse of vindication for him. This is not a close call about which reasonable officers could differ. The law, as it stood at the time of the events in question, left no doubt that a person in possession of a firearm and a facially valid permit for that firearm had a clearly established right to be free from the kind of forcible and prolonged detention to which Sakuna was subjected, absent any objective reason to suspect that the permit was forged or otherwise invalid. This wasn't even a close case. It's not like Officer Andruski made a judgment call supported by the law. Rather, he ignored the law, apparently assuming that a lawful gun owner was, by definition, suspicious and dangerous. That type of thinking is what got Mr. Andruski in trouble. For those reasons, we hold that Andruski's alleged conduct violated Sakuna's constitutional right, where the detention constituted a de facto arrest without probable cause, and where case law from the Supreme Court and this circuit clearly established Sakuna's right to be free from such detention under the circumstances. I agree with the court, but I would have gone one step further. Yes, Officer Andruski violated Mr. Sakuna's rights protected by the Constitution of the United States. Officer Andruski's actions were not only reprehensible, but were criminal. So under 18 U.S.C. Section 242, we find, whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. Mr. Andruski clearly deprived Mr. Sakuna of rights protected by the Constitution and laws of the United States, and did so under color of law. Furthermore, since Officer Andruski allegedly roughly removed Mr. Sakuna from his vehicle and tossed him in the back of his cruiser, it is quite possible that Mr. Sakuna was injured by the illegal actions of the officer, triggering another part of Section 242. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosive, or fire, shall be fined under this title or imprisoned not more than 10 years or both. It seems to me that Officer Andruski should face criminal charges for his actions, though that was not the question before the court. The question was, did the district court err by denying Officer Andruski's motion of summary judgment and dismissal under qualified immunity? Thankfully, not. For the foregoing reasons, we affirm the judgment of the district court and remand the case for further proceedings consistent with this opinion. That doesn't mean Mr. Sakuna's ordeal is over. The decision merely means that the district court can proceed with Mr. Sakuna's lawsuit based on the facts at hand. Mr. Sakuna has a long way to go before he finds out if he will receive a favorable redress of his grievance. Even if Mr. Sakuna wins his day in court, this does not mean that Officer Andruski will be personally punished for his crime. Since this is a civil lawsuit, the City of Waterbury, Connecticut will pay any judgments against Officer Andruski. Unless a criminal complaint is filed, there will be nothing to prevent Officer Andruski from doing this to other law-abiding citizens who are not only exercising their right to keep and bear arms, but complying with the unconstitutional and therefore invalid laws that Connecticut has put in place. If complying with the law is not enough to keep you from police harassment, how can we call ourselves a nation of laws, not of men?